Viewers and listeners, welcome to the Carbone Lawyers podcast series, known as the Law Lab. As you can see, we're practicing social distancing. My name's Tony Carbone. I'm the managing partner of Carbone Lawyers. Today I've got Joseph Carbone, a senior associate at Carbone Lawyers in workers' comp and litigation. G'day, Joe. How are you?
G'day, Tony. How you going?
And an up-and-coming superstar of the law, Stacey Patsias, a litigation lawyer at Carbone Lawyers. How are you, Stacey?
Hi, Tony.
Joseph and Stacey, today we're going to do a very important episode on probate and administration of estates. What's important is that there's a lot of tricks to it. You have a will, but does it apply? Before that, Joe, there's a couple of very interesting stories in the media. There's been an absolute bombshell that's been issued by the state parliament on wage theft. Tell us about it, Joseph.
Yes, just recently a bill was passed in Parliament making it a criminal offence to deliberately withhold wages from employees if you're an employer, and the penalties can be as serious as up to 10 years in prison, just shy of $1 million for a company breaching these laws, and for individuals just shy of $200,000 in fines. So very significant indeed.
Stacey, it is big because the situation is that in a lot of instances, employers, sadly, inadvertently or whatever, are underpaying their employees. So they're heavily exposed. What it means is they should really get outside independent HR advice, shouldn't they?
Oh, definitely. Yeah, HR advice would be key.
Yeah, look, in saying that as well, I mean, there have been some pretty shameful breaches of quite clear legislation in terms of wages that we've seen in the media, especially the last couple of years. The lid's really been blown off. So, you know, in saying that, I know that there's a lot of duties on employers, but at the same time, I don't necessarily think it's a bad piece of legislation when someone's, you know, seriously breaching the law and flagrantly breaching the law as well.
Apart from any criminal prosecutions or fines or jail terms, what's important is that the employee's got the right to sue for back payments. And I've got 2 or 3 cases at the moment. I've got one that's been underpaid for 25 years. I've got another one that's been underpaid 18 years and another one 15 years. Now, if you do your numbers, you're talking into the hundreds of thousands of dollars. And so the employers have to fork out this money. It's a pretty big hit in one go, isn't it?
Yes, it sure is. I mean, look, in many aspects as well, there are cases where, you know, there's indexation and whatnot, plenty of things that employers have to look out for. But look, as I said, I'm of the view that this legislation is mainly for the most serious types of breaches.
And for you employers out there, what you've got to be careful of is this. In a lot of instances, you've got people down as subcontractors or casuals, but the reality is if they're only working for you, under the Fair Work legislation and our work cover legislation, they're what they call deemed employees. Now, if they're deemed employees, they're entitled to holiday pay, long service leave, sick leave, all of these entitlements. So please get some proper HR advice. Now, Stacey, remember that incident at the Box Hill Hospital where a heart surgeon went to tell a guy to butt out his cigarette? What happened next?
Tony, he was punched in the head by the guy who was smoking, and the wife is now suing the hospital for failing to keep the doctor safe.
In this case, see, the poor bloke, when he got hit, he's fallen on the ground, and as usual, they hit their head, he passed away.
Yes.
Now, he's an employee, isn't he?
Yes, he is. Look, a very, very sad case. As we've previously discussed, though, in previous podcasts, it's all going to come down to foreseeability and reasonable foreseeability. So Mr. Stegman's widow is going to have to prove that the hospital, as his employer, was on notice that this was a real risk of occurring, that there'd been a history of aggression in the hospital before. And if she can find that it was reasonably foreseeable that an act of aggression could lead to this, then she could very well be awarded damages.
I don't see it being a problem, guys, because if you go back about 7 or 8 years, it could be even more now, the surgeon, spinal surgeon, Mr. Wong out of Footscray, he got stabbed by one of his patients who, for some reason, just went crazy and stabbed him over 30 times. He survived. And so as far back as then, these hospitals were aware or on notice that these sorts of incidents could occur. So I wouldn't think that that's a problem, Joseph. But apart from that, Stacey, there's a no-fault benefits of the dependency benefit, isn't there?
Yeah, definitely. And I think that's something that she can also consider.
Yeah, and that's pretty big, isn't it, Joe? The no-fault benefit, over $500,000.
Absolutely. And what that essentially is if an employee passes away throughout the course of employment, their dependents, i.e. their children's or their widow, can make a claim for assistance moving forward, because obviously the loss of income over a number of years is massive.
There's going to have to be a balancing act here, because the situation is you've got to work out whether they're better off to stay on no-fault benefits, because the children are entitled to benefits until they finish school, and the wife's entitled to benefits almost indefinitely. Anyway, let's move on from that. Stacey, we've got an interesting topic here, probate intestacy and testator's family maintenance. Do you want to give us a bit of a summary of what that all means?
Yeah, so probate is an application that's made to the Supreme Court if a person has died, leaving a will behind, basically distributing his assets to family members or friends or in any way that they want to. And the application is made by the executor who's appointed by the deceased. And basically that application, or the grant of probate also known, gives that executor the power to be able to do that. And
to administer the estate.
Correct.
Yeah. Well, Joseph, in circumstances where there's no will, what happens there?
That means that the person died, the legal term is intestate. I think people would be surprised to find that there's been quite a few cases of unclaimed money. I think up in New South Wales there was an estate of a few $1 million where the person didn't leave a will. It can become rather messy.
It can, but in today's age as well, it's a very similar process. You can apply for what's called letters of administration with the Supreme Court, and basically instead of the executor being appointed, it just follows the rules of the next of kin. So, for example, if the deceased was a husband, it'll then go to the spouse. If the spouse is not alive, it'll go to the children, and so on and so forth.
Yeah, but there's limitations on that too, Stacey, because if you want the spouse to get the asset, unfortunately the Administration and Probate Act has got formulas on what they get.
Yes, correct.
I think the spouse gets just over $100,000 initially, and then children get the balance. That's it. There's a really funny, strict formula, isn't it?
Yeah, and if you haven't administered the estate within 3 years of the deceased's death, the court may actually ask you why the delay and why you haven't done it within that period.
Joseph, with probate, the executor's got to be careful too, because at the end of the day, if they don't do it properly, they can be sued.
Absolutely, and that's a very important consideration.
And for people out there, you know what they've got to be careful of, guys? When you nominate an executor, under the Supreme Court Act, the executor can charge 5% fees to the value of the estate. So you'd be wanting to be very careful who you do appoint as the executor. One, you should trust them. Definitely. And two, you've got to understand that they can charge a 5% fee on the whole estate.
And that's why knowing what the property pool or the asset pool is from the beginning is very important, because one of the documents that need to be lodged is called the Inventory of Assets and Liabilities, and they need to detail exactly the total and final amount of the estate. And if the executor can then claim 5%, if the estate's not worth much, well, then you're really losing.
Yeah, but if the estate's worth $20 million, doing numbers,
different story.
The executor picks up $1 million just like that, you know what I mean, which is a lot of money. Anyway, Stacey, more importantly, I do a will, for example, right? With the amendments to the legislation in the last, say, 5 or 6 years, sometimes these wills don't really mean much, do they?
No, not really.
Because, Joseph, you can do a will, but anyone that is a spouse, spouse, de facto,
A dependent of some sort.
A girlfriend, a boyfriend.
Yes.
It's dependency, isn't it?
And further to that, in Australia, most contested claims are actually successful. I think the rate's about 70 to 80%
very high.
Of all contests actually have a successful outcome. So just because there's a will doesn't necessarily mean that what's in the will will be, or the assets will be distributed according to what's in the will, because there's some grounds to actually contest a will that somebody may have made before their death.
And Stacey, you can have a will that says, I want to exclude this child because I haven't seen him, or there's no love and affection for over 20 years, but that's not the test.
No, it's who has the most needs.
Yeah. So if that particular child that you want to exclude has got no money and is absolutely dependent on you, they will get their hands on that money, correct?
Correct. Sometimes having that clause in the will may give you some form of protection, but it's not always the case.
Do you recall when Whiteley, you know, the famous artist, Australian artist, when he passed away, there was an ex-wife, there was a girlfriend, there was a child. I mean, every man and his dog tried to get their hands on his estate. And as it turns out, those paintings were worth a fortune. So it was a pretty substantial sort of estate, wasn't it?
Yeah, definitely.
What's really important for the viewers is if there's a will and once you've obtained what they call probate or letters of administration, if you're one of these aggrieved people out there, one of the children, a spouse, a girlfriend, someone that thinks that you're entitled, or you might have even paid money to the deceased, or you might have helped them with house maintenance or home renovations, or just looked after them during their lifetime, you've got a right on the estate, but there's some pretty strict time limits, isn't there, Stacey?
Yeah, definitely. You have to make that application to the Supreme Court within 6 months from the date of the probate being granted.
And Joseph, unfortunately, those 6 months are pretty strict. So if you as an aggrieved person do not make application within the 6 months, you lose your rights.
Yeah, that's right. And I think that's, I like saying this, but I think the best thing to do is seek legal advice. If you think that you may have a claim, you should seek legal advice as soon as possible.
And viewers, in this day and age, it's amazing how with the changes to the Administration and Probate Act and with this dependency test, how it's become more and more trickier. Because once upon a time, the wills could specify who they wanted to get money and who they didn't. But quite frankly, and I don't want to be rude to all those probate lawyers out there that are doing wills, but more often than not, depending on the circumstances of the aggrieved person, they're probably not worth the paper they're written on. Is that a fair comment?
Yeah, it is.
Joseph?
Yes, it is. And I think going back previous years, that a major gripe for many people was that the eldest sibling would receive the lion's share of the money. And there'd been plenty of issues. However, as time goes on, things have changed in that aspect.
And also, guys, with these wills, there's a lot of trickstorm because there was one that I saw where the mother left one of the two siblings a life interest in a property that was worth $4 million, right? Now, the sad thing about that is that when the brother passes away, unfortunately, the other sibling will miss out because then the estate will go according to his will. So a life interest can be pretty damaging too, can't it, Stacey?
Yeah, it can be. And I think with those types of interests, a lot of people try to avoid doing that because it gives rise to a lot more complication than what it does good. So if you're going to disperse something, you know, in a will, you've got to be very careful with what you give and how you give it because you might damage your actual estate.
Joseph, the reality is this. You do a will so that at least you know you got peace of mind. At least you know they're going to bury you properly. I mean, if anything.
And not only that, but I think it reduces the level of heartache that your family members do have. Firstly, they're upset because you've passed away. Secondly, you don't want them exactly squabbling and having to haggle over who gets what and how they get it and whatnot. So I think the best, most responsible thing to do is to organise your affairs, before you pass, and obviously, in a timely fashion. And it doesn't actually have to be once you're in at older age. And
plus, you've got to make sure you do one when you're still at what they call testamentary capacity, because at the end of the day, there's no point trying to do a will when you're at a stage where you've lost your mind. Or
Stacey, isn't that a major area of contention when people are trying to dispute wills? They're trying to say that the deceased who did the will did not have sound mental capacity to do so.
Yeah, it is, definitely. Because instead of, for example, if you want to go down the Part 4 application for a testator's family maintenance claim, you also have a right to contest the validity of the will. And if you think that the testator or the person who's making the will did not have capacity at the time of signing, then you can definitely challenge that.
And viewers, the best way to challenge that is go to the doctor that was treating the person that did the will. you'll find that they've probably had the same GP for the last 30, 40 years. And once you get the doctor's notes, there'll be references to dementia perhaps, or not being able to make decisions. And that's how you'd really be able to look into whether the person was of sound mind and had testamentary capacity. Is that right, Stace?
Yeah, that's right. And that's why we would suggest that if you are doing a will, perhaps go to the doctor beforehand and get a letter that says this testator has capacity to write a will, and then have that at the back of the will when it's lodged. That way you're protected and you have no issues if anyone trying to contest the will.
And Joseph, if you don't fit the definition of dependent or dependency, you've still got rights if during the lifetime of the person that passed away, you as a person that want to challenge a will, either contributed in terms of finances, you might have helped them pay off a mortgage, you might have paid for some renovations. If you can produce evidence to that effect, you can challenge a will.
Correct. The discretion of the court is rather wide. The powers of the court are rather wide. So you should keep any documentation. That's why you should probably never throw any documentation out. But yes, the powers of the court are very wide in how they can grant or break up an estate.
And significantly, viewers, in most instances, the legal fees associated with challenging a will, unless the case is frivolous and the court finds against you, the fees come out of the estate.
Correct, because this is a very cost-sensitive jurisdiction. Anything that's paid out is paid out of the estate. So you could be very careful with what's actually being claimed.
And viewers, do a will because at least you can appoint an executor/executrix, which is someone that you generally trust and you know that they'll do the right thing by you and your loved ones. Is there anything else you want to add, Stacey? Because I think we've covered off on most things.
Yes, Tony. My advice would be please seek legal advice as soon as possible. Go to our website. If you have any queries, please lodge your query online or give us a call on 1-800-369-888.
And viewers, the important message I want to send is this. If there's been a situation where a loved one's passed away and if you think you haven't been looked after, don't mull over it. Don't sit on your rights. You've only got 6 months. So get your act together, contact the lawyer that practices in this area and knows what they're doing, and it won't cost much. It'll be a lot cheaper to get that advice early, because then if you sit on your rights, you've got no rights. We've come to the end of the show, guys. Thank you so much for being part of it. Stacey, Joe.
Great talking to you both.
Thanks, Joe. Thanks, Tony.
Viewers, thanks for watching and listening. Go to our Instagram, Facebook, YouTube, all the social media channels, and stay tuned for our future episodes, and please always remember to stay safe.
Don't settle for